Jurors gearing up for another explosive week in the murder trial of former Minneapolis police officer Derek Chauvin. Week 1 filled with disturbing details, painful videos, and powerful testimony as witnesses relived what they saw that day, like the store clerk who said he feels guilty for alerting his manager he thought George Floyd used a counterfeit bill, setting the events in motion.
Why guilt?
If I would have just not taken the bill, this could have been avoided.
I do.
The prosecution also calling on law enforcement officials to testify against one of their own.
Putting your knee on the neck for that amount of time is just uncalled for.
The defense claiming the crowd of bystanders growing louder as the minutes went on distracted Chauvin, pressing firefighter Genevieve Hansen, who told the jury she wasn't allowed to offer medical aid.
Would you describe other people's demeanors as upset or angry?
I don't know if you've seen anybody be killed, but it's upsetting.
He's not responsive right now, bro.
And bystander Donald Williams, who can be heard shouting at Chauvin.
Those terms grew more and more angry. Would you agree with that?
They grew more and more pleading for life.
The defense expected to continue arguing Floyd's drug use and heart issues contributed to his death.
I am so excited today. We have with us the chairman of the board of the Rainbow Push Coalition, but also she's president of the National Bar Association, the largest African-American bar association in the world. We have none other than attorney C.K. Hoffler, who's going to share some insights for us into the Derek Chauvin trial.
First of all, we have to label it as the Derek Chauvin trial. It is not the George Floyd murder trial. It is the Derek Chauvin trial. So, and the reason why I say that, mainstream media has reinforced the notion that George Floyd is on trial. And indeed, that is the defense's position. So just to kind of set the table, when you have a criminal case, it is very different from a civil case. A civil case, let's say if you had an automobile accident or a wrongful death action, meaning you went to a hospital and a doctor was negligent in his or her treatment of you, of a loved one, that's a civil claim that you would bring against the doctor, against the driver of a vehicle, or someone who has done wrong to you in a civil court. You would hire a lawyer and you would be a plaintiff. And in that instance, in general, the burden of proof, meaning what you'd have to prove to win your case, is by the preponderance of the evidence in general. And in some states, they call it the greater weight of the evidence. And I like to equate it to the scales of justice. The scales of justice are supposedly even when people go into a case. The greater weight of the evidence just ever so slightly tips those scales. That would be 50.000001. Ever so slightly tips those scales in favor of the plaintiff or defendant. And that is what is meant by the greater weight of the evidence for one party or the other to prevail. That's what we call the burden of proof in a civil case. And the Derek Chauvin case, and in most criminal cases, actually in all criminal cases, the burden of proof is completely different. Meaning you've got to prove your case if you're prosecuting the case. So remember, in a civil case, you've got the plaintiff's lawyer and you've got a defendant's lawyer, the defense lawyer. Plaintiff's lawyer and defense, that's civil case. Criminal case, the terminology is different. You've got the prosecutor who's bringing the case on behalf of either the state or the feds. So you have federal prosecutors, you have district attorneys, but they are prosecutors who are prosecuting a crime. So in the case of Derek Chauvin, the crimes surround what Officer Derek Chauvin did, which led, in my impression, to the death, the killing that led to the death of George Floyd. Why do I say in my impression? Well, this is a trial. So the prosecutors have to prove, and then we get into that standard, beyond a reasonable doubt. Remember, we said in a civil case, it's just slightly tip the scales. In a criminal case, it's different. It's got to be off the top, really, I say out of the roof, where you've got to prove your case beyond a reasonable doubt. So you have to prove that case that this person, in this case, Derek Chauvin, murdered George Floyd. Now, many people would say, well, of course he murdered George Floyd. I saw it. Initially, I saw it in 8 minutes and 46 seconds. Well, we now know it was 9 minutes and 29 seconds where he had his knee to his neck and was pushing on it more and more and more until he died. As the prosecutor said in opening statement, just trust your eyes. If we trust our eyes, most people would say, well, if we trust our eyes, we saw him actually kill George Floyd. Makes sense to me. I would agree. But when you have a trial is about laying the evidence and proving your case. It's not enough to just show the video, even though the video is by far, the most compelling evidence in the case is that video, 9 minutes and 29 seconds of Derek Chauvin killing George Floyd. Most compelling. First degree, second degree, third degree murder. What that means is there are varying levels of elements that you have to prove. And it goes to the intent. You know, there's one thing when people are negligent. I negligently did something. But if to really prove murder, there's got to be reckless disregard. There's got to be that intent to harm, that intent to kill. And I believe that the prosecution will have evidence to show that. Let's talk about where we are now with the evidence that's been laid. The prosecution has laid, I think, a pretty compelling case. You know, in a trial is very, very volatile. You never know how the evidence is going to come out. But by and large, with the exception of maybe a witness here or there, the evidence thus far has been very compelling to demonstrate that indeed Derek Chauvin murdered George Floyd. From the witness statements, from the most compelling piece of evidence, the video, from the words, most compelling evidence to me was the words of the police chief that said, in essence, that Derek Chauvin's conduct fell outside of the training that he received as a police officer for handling those types of situations. And then that police chief said, let's go a step further. He spoke truth to power. He told the truth. He stood up and said he should have stopped putting pressure on his neck and choking him once George Floyd was subdued. And we know from the video that was early on. And definitely once he started pleading for his life that he couldn't breathe. So you see, there were minutes and seconds. And as you know, when it comes to our airwaves, minutes and seconds count because they make the difference between life or death. So very compelling evidence. I'd also like to point out the evidence that was and the testimony of his girlfriend. The reason why I'd like to raise that is I believe that even though people may have known that his girlfriend was white or was Caucasian, the reality of seeing this white young lady testify about how she loved this Black man who the defense, ladies and gentlemen, the defense is going to paint George Floyd out to be a big, bad King Kong-like gorilla who was unruly, out of his mind, on drugs, sick, bad heart, had every ailment and was a bad person. They're going to demonize him because they're going to turn this case around and make it not about what Derek Chauvin did, his breaches, his actions, his deviations, his violations, his tactics, his oppressive actions. And they're going to flip the switch and pivot to how bad of a person George Floyd they're going to submit was. His medical condition. So then the reasonable doubt, that's what they're going to try to do, to inject that reasonable doubt in the minds of those jurors that there were other things that were responsible for the death of George Floyd, other than putting his knee on his neck for 9 minutes and 29 seconds. That's going to be how they're going to attempt, I would predict, and how they've tried to do thus far, to create that reasonable doubt for the jurors to feel somewhat uneasy about George Floyd, that uneasy about this relationship that he had with this wholesome looking white woman who testified about how she loved him, how he was loving, how he was a mama's boy, how he was caring. That's different from the image the defense is trying to portray. Remember, in a criminal case, you've got the prosecution prosecuting. That's what we see first. They put their case on first. And then you've got the defense. That's those who are defending the police officer. And indeed, in this case, they're defending really law enforcement. Although that's why it was so compelling to hear from the police chief, because he's law enforcement, rank and file, the chief who's saying, oh, wait a minute now, I got to call it how I see it. Derek Chauvin violated what he was taught, the training, the ethics, and the professionalism expected of a police officer under these circumstances. And then he dissected why he felt that way. So the defense, we have to wait. And remember, it's not really how we feel that's important, it's how those jurors feel in the courtroom. Earlier today, I have a radio show. And on my radio show, I had Jonathan Jackson, who's the national spokesperson of Rainbow Push. I also had Ben Crump, who is the lawyer to the George Floyd family and who is a civil rights lawyer extraordinaire. And I had George Floyd's brother. And Ben Crump and George Floyd's brother came out of the courtroom to give our listeners an idea of what it was like inside there. Because while we see things on TV, it is what that jury sees and perceives. And there's certainly a different dynamic when you're there and you're looking at the witness. The witnesses testify day in and day out as they are. So in sum, as some people say, oh, this is a slam dunk, there's no such thing as a slam dunk case in litigation. It does not exist. There's compelling evidence, but remember, the standard of proof, the burden that the prosecution has is beyond a reasonable doubt. Indeed, I think they're well on their way. They've got to do a little more, in my humble impression, going to the intent, going to the relationship or knowledge that Derek Chauvin had of George Floyd. After all, they did work at the same, Derek Chauvin moonlighted at a club, and George Floyd also worked there. So they were in a sense, colleagues, if you will. Derek Chauvin, I would dare say, knew who George Floyd was, knew the kind of person he was, had developed an impression of George Floyd, knew the kind of people that he was surrounded by. He knew that he was very affable, popular at that club that they worked at. This was not just someone who was random. Derek Chauvin, when he approached George Floyd, knew who he was, and his actions, that 9 minutes and 29 seconds against his neck, killing him slowly, painfully, deliberately, intentionally, in my impression, will mean something to that jury if the evidence is laid that way. Derek Chauvin's not going to take the stand. He might. I doubt he would take the stand. That would be suicide for him in this case, but maybe he might. So, and if he did take the stand, he's not probably going to admit to the kind of relationship I'm talking about that must have existed and how he felt about George Floyd. It could not have been a chance encounter that day. What about the alleged $20 counterfeit bill? That kind of got lost in the shuffle. We didn't hear any evidence of the police officers or Derek Chauvin going back into the store looking at that evidence. George Floyd died, as Jonathan Jackson said today, with probably not even understanding why this was happening to him. Because if you pass a counterfeit bill at a store like that, death is not what would result in criminal prosecution. Some type of misdemeanor or something, but not death. Not death that way, with a knee at your neck, handcuffed, where every living breath that you take is stomped out of your body. No, that's not what happens for, even if it were true, an alleged $20 counterfeit bill. So, ladies and gentlemen, this trial has major local, national, global, international implications. It brings together the civil rights community, the human rights community, the forces of policing reform, criminal justice reform, and bare bones justice in this family, all together with race, because for sure, the racial animus that may have existed in the heart of Derek Chauvin can be deduced from the evidence that we've seen at this point. And at a minimum, although the judge would not allow prior bad acts where he had done something similar to others, this chokehold thing that he used, there were other instances. And even though the jury was not able to hear that evidence, at least not thus far, that would be compelling. And the judge made that ruling. The judge made a determination between the probative value, meaning the value of that evidence, what does it tend to prove, versus the prejudicial effect of the evidence, and excluded that. And so the jury's not going to hear that, at least not thus far. So I think we've got to look at this case very carefully, listen to the evidence, but more importantly, trust what we see. Trust what we see.